Good afternoon. My name is Dr. Alfredo Suarez-Sarmiento Jr. And today my research paper presentation is about the case of Leonard versus PepsiCo Inc., the United States District Court for the Southern District of New York. Again, my name is Alfredo Suarez-Sarmiento Jr., and this is my research paper for Business Law 6810. Well, to start off, to give a little background for some people that aren't old enough to remember this commercial. The 90s had major corporations all were trying to get in this redeem product points for merchandise or what have you. Everyone from Pepsi to Coca-Cola to Marlboro cigarettes, everything. You could see the gear everywhere. And this was around that time, 1996. Pepsi aired a commercial advertising a new rewards program they were offering called Pepsi Points. They showed several items at their point cost. They would give t-shirts, sunglasses, and the one commercial was very famously about a teenage kid showing up to school in a Harrier jet that he earned by drinking 7 million Pepsi points. The advertisement began with a catalog and then would show all the items that were in the catalog except the Harrier jet. The magazine said that any reward could be ordered as long as the order had at least 15 Pepsi points, as remaining points could be purchased for 10 cents a piece. The plaintiff, Mr. Leonard, raised $700,000 from acquaintances and gathered 15 Pepsi points. He then submitted an order form for his one Harrier jet with 15 points and a check for $700,008.50 to cover the remaining points in the standard $10 shipping. Right off the bat, Pepsi rejected the offer, however, and they said politely, I'm sorry, but we can't accept your offer because this wasn't real. It was a satire commercial, and we're sorry that you misunderstood, and they sent him a case of Pepsi. The plaintiff responded by demanding that he would receive his jet or he would pursue legal action. Around this time, he had already had legal counsel, and Pepsi had forwarded this advertising company saying that it was clearly a joke, but they had to ask the advertising company if it really was a joke. There was a lot of questions being asked, and I guess a lot of people didn't have answers. The defendant then filed a suit seeking a declaratory judgment, and the plaintiff filed a suit in response. Now, I'm going to show you a little clip of what the commercial was from 1985. It's about 45 seconds. But 45 seconds caused about 6 years of litigation. You can tell how retro the tech is the commercial came from.
Introducing the new Pepsi Stuff catalog. Now, more Pepsi you drink, the more great stuff you're going to get. It sure beats the bus.
As easy as that, that's the commercial that started all this fuss. It seems very plain and simple. 45 seconds, it's not even that big of a commercial, right? But somehow, in the fall 1985, after they ran this commercial, they actually ran this commercial only in the Pacific Northwest of Seattle before they did the big rollout. And like I stated before, the offer was simple. Buy Pepsi, get points, get stuff. Drink Pepsi, get stuff. It's right there. And, like we said before, prior to the global rollout, they went to the Senate, and that's where our plaintiff, Mr. Leonard, says his excuse was that as a Pepsi millennial generational person, that he believed that the offer was real because, people who drink Pepsi are outdoorsy and excited and they get to do all these things, and, that the commercial inspired him to have this, and that's why he could not give up this relentless chase to get this plane. Now, an interesting thing is advertisement as offers. Traditionally, even per our textbook, they say whether ads are offers when they do not include clear terms or a place, time, or manner of acceptance, or whether they are merely invitations to negotiate. Now, traditionally, they say that advertisements do not constitute an offer unless there is a clear and definite and explicit term set and there's no room to negotiate. Whether an offer has been made depends on the subject of the reasonableness of the alleged offeree's belief that the advertisement or solicitation was intended as an offer. An obvious joke would not give a rise to a contract, but that's the whole point. What is a joke and when is not a joke? The commercial made no mention of the steps required to accept this alleged offer, instead relying on the physical catalog to provide those details. Now, Mr. Leonard believed that just because the jet was not in the catalog doesn't mean that it's not part of the offer, because according to the commercial, it is. It's there. The number of points are there. What you need to do, redeem it, is there. And to him, it made sense that it was a true offer. But the courts decided that since those details were not provided, that in turn did not constitute an offer, and since the commercial did not seek to introduce a specific action, it merely sought a reciprocal promise and compliance with the terms of the order, meaning that Pepsi wasn't telling you to go do something, they were only encouraging you to go redeem points. Now, the United States District Court for the Southern District of New York was the one that finally had the last say on this subject, because originally the case started in the Northwest. Mr. Leonard and his attorney moved the case to Florida due to different statutes that gave him a more favorable outcome there. And finally, Florida said that, look, yeah, this has nothing to do with us, this, what have you. And then eventually it was turned over to the United States District Court, and the Honorable Judge Woods was the one that proceeded over the case, and she decided, or she ruled, that no objective person could reasonably have concluded that the commercial actually offered a jet, that it was an obviously joke of zany humor, that there was humor involved. Now we have the circuit court judge is trying to dissect what is humor and what is not. And Mark Twain famously said that when you try to dissect humor, just like biology and frogs, they both end up dead at the end. And essentially that's what happened in this. Every single aspect of the court case was from the commercial. From each thing, they had to prove why that was funny and why someone would find that in jest and not find that in jest. So that exaggerated claims that a reasonable viewer would understand as mere puffery. You know, realistically, it was improbable that a high schooler would fly the Marine Corps prize aircraft, which cost $23 million, without a helmet, instrument checking, or consideration of danger. Other parts of the commercial that were exaggerated, such as blowing a teacher's clothes off, a school would not condone the disruption of the jet's use, which would provide landing space for such a vehicle. You know, these are all aspects that you saw 40 seconds, and they had to dissect this like if it was, you know, a 5-hour movie. Now, another part was that the Harrier jet's primary mission, according to the United States Marine Corps, is to attack and destroy surface targets under day and night visual conditions. It is designed to carry considerable ammunition, including 9,000 pounds of bombs and missiles, that no possible civilian is allowed to own. I mean, only the government is allowed to own these, and only military personnel are allowed to fly them and navigate them. And now, to acquire the requisite 7 million Pepsi points, this was their other point, you'd have to drink 190 Pepsis per day for 100 years, an impossible amount, or buy the $700,000 in Pepsi points. The cost of a Harrier jet is roughly, like I said before, $23 million. So a deal this likely is usually too good to be true. Now, what precedents were set by the verdict? The court said that the restatement second of the contracts, Article 26 and 29, which state that manifestation of a willingness to enter a bargain does not equal an offer if the person making it doesn't intend to conclude the bargain until he's assented again. Basically, it's saying just because you really want to accept this offer doesn't mean that the original party is actually offering it. Your willingness to want something is not enough to say that an offer has been created just because it is one-sided. The court also stated that the general rule is that advertisements do not create any power of acceptance. The one exception was being described in the Lefkowitz case, where a company was offering free, and this was a long time ago, it was 1959, were free fur coats for the first three customers. No, dollar fur coats for the customers that would show up at 9 a.m. Well, the first person there was a man, and the company, the fur company, said that they would not sell it to him because he was a man. But when it went to trial, they said nowhere in the ad said men couldn't buy the coats. It said the offer is for $1 at this time at this place. That set precedent. That's one thing the Pepsi ad did not do. The Pepsi ad just said 7 million points. It didn't say check them in, and it made continuance referred to the Pepsi catalog, which didn't even have the jet in it. So basically, that's essentially what happened. Now, what they didn't speak about in the actual case is that Mr. Leonard tried to have the same thing with the leather jacket. It turns out that the leather jacket from the commercial was also not in the catalog. And he had another lawsuit that eventually got bunched in with this one because he wanted the leather jacket. Now, the question determines, had he originally asked for the leather jacket and not the jet, would he have gotten it? I'm sure they would have. Pepsi probably would have settled right away, and, but they would bypass the 5 years of litigation that they had to deal with, almost 7. And then lastly, the court said that the ad failed to meet the Lefkowitz standard, which I just explained, where ads do not equal offers, and if and only if they are clear, definite, explicit, and leave nothing open to negotiation. For example, unilateral offer where you see a sign that says reward for lost dog, you find the dog, you take it to the place where the reward is offered, and they give it to you, and now that is a binding contract, which this did not have any of those aspects. I mean, personally, it seemed a little too too good to be true, but the guy was trying to work the system, and clearly it didn't work out on his own. Just a few takeaway points that I want to state that as far as this goes with healthcare and medicine or what have you, we are in a society right now where you go to a hospital, a healthcare provider, and all of a sudden you're getting surprise billing and all these different charges that normally don't do. Personally, myself, I had shoulder surgery, and I was told over the summer that I had to pay a certain price, and that was it. It was binding. I pay this one price, and that's it. And for the last 4 months, bills keep coming in, more here, more there, and you call a hospital, you ask and this and that, and oh, well, that was part of your contract. I was like, no, you told me one thing, but now you have to read the fine print. They're able to change things whenever they want. So just because you think it's binding doesn't mean it's not. So basically, from a doctor's point of view, because I'm a doctor and I still see this all the time as a patient, we're not safe from the big healthcare organizations. So a person has to be aware of what is feasible as far as a contract goes between both parties and how the outcome will become. Just to read some of my points here that, as I said before, now with today's society, consumers are subjected to a barrage of ads which make promises which most companies do not plan to keep. And that goes from pills that you see on TV, healthcare insurances, everything. So many consumers are subject to these ads, and sadly, the people that are uninformed might take this as true, as some of these things will cure whichever ailment they has, or do they have this, or do they not? The case of Mr. Leonard did not conclude in his favor due to the sheer absurdity of the offer he believed he was made, but hopefully these findings can one day help someone in his position when they are asked to comply with a contract that they found to be incredulous and unreasonable. Judge Wood's verdict against Mr. Leonard was based on the premise that the commercial was merely an advertisement and not a unilateral offer. The satirical nature of the commercial would not cause a reasonable person to conclude that PepsiCo would be offering Harrier jets as part of the promotion. And lastly, since there was no written contract between the two parties to satisfy the U.S. statute of frauds, sadly, the case had no legs to stand on. Hopefully, you learned something from this presentation, and maybe it can help you forward in your career or what have you. I hope everyone has a nice rest of their day. Bye.